Celebrating 75 years, the ILR School at Cornell University. ILR, shaping the next 75 years of work.
This is Harry Katz. I serve as director of the Scheinman Institute on Conflict Resolution at the ILR School, Cornell University, and we've been doing a series of interviews with conflict resolvers. We're asking those individuals how the pandemic has changed both the substance of what they do and how they do it. The individuals we've been interviewing have a connection to the Scheinman Institute, either because they serve as one of our board of advisors or because they teach in one of our programs. No one is more connected to the Scheinman Institute than Martin Scheinman himself. Marty, as you know, is an active mediator and arbitrator. He does traditional labor cases. He does employment rights issues with non-union, unrepresented employees, and he does commercial disputes. And it's my pleasure to welcome Marty into this interview.
Good morning, Harry. Nice to see you.
Nice to see you. So let's just get started. The pandemic, how's it changed the nature of the cases that you're working on? I know you've remained incredibly active. How's it changed what you do?
Well, I think it hasn't changed it generally, but some of the topics we're dealing with obviously are COVID-based, and we have issues of dependability, people with psychological issues about whether they can come to work or not. A lot of businesses are under stress. The more they're under stress, the more there's conflict. We have partnerships that are breaking up, which is probably not coincident given what's gone on. We have cases more about financial exigencies. What do we do about in collective bargaining, monies that were owed that we can't pay, business deals that were agreed to, but now there's an assertion you can't pay, litigation that was settled with payment plans that are not being paid in the way in which they were anticipated. So all the kinds of things you would think would happen are happening. But, you know, we still have all the same kinds of things that I dealt with for the last 40 years.
Yeah. So have the cases changed at all since there's been something of a return to work? You know, have there been more issues about who gets called back, or changes in disputes regarding protection, or maybe even the beginnings of questions about are vaccinations going to be mandated and required? Have the cases evolved?
Well, all of the above. Either they are already teed up to be decided, or the parties where I'm the permanent arbitrator are talking about these. So, for example, what's the order of bringing people back? There have been entities that have given people premiums or hazard pay for coming to work, and now are they going to continue? The workers now going to actually get less money now than they used to get. On the other hand, the employer is saying this was very hard to pay. Do we have enough protective gear? Do we have? Are we going to require people to have vaccinations? If we're not going to require them, are we going to tell the person who sits next to someone whether or not that person they're sitting next to has vaccinations? There's a lot of law evolving. The Labor Board and others, the EOC, are starting to talk about this. But, you know, back in the trenches where we deal with this on a day-to-day basis, parties are asking these questions. I've opined on some. We've had discussions on some. Some will be agreed to. Some I think we're going to have fully litigated, and we'll have to decide. I'll have to decide with my team what we think about this. It's very prevalent in transit, schools, obviously healthcare. A lot of healthcare wasn't open. Now it's going to be open, and people are, what's that going to look like? And, you know, supervision, scrutiny, people, are you going to have a right to say I opt out because I have a specific condition? I have asthma, I have something else, you know. So these are all going to be issues that are coming up. They're being anticipated. We've been talking about it for a while, but now that they're here, they're probably ready to be at least tackled in some fashion.
So I know you're involved not only in mediations and arbitrations, but sometimes in negotiations itself. Have you found that there's a certain type of dispute that isn't coming forward, or is it that everything is happening? You're doing you know, the same diversity of types of cases as you had in the past?
I do think that you know, it's always hard for a neutral to know what's not coming. Mm-hmm. But I sense that the parties are a little bit more aware of the public perception about, are we really spending resources arguing about, for example, where my parking spot is? Are we really going to spend time and the like on issues that seem not to be that significant? Can we even justify the cost of some of this when we're had situations where people either were laid off or have taken reductions? So I think there are some cases that are either going to be put in the back burner, or the principles are now put in a little bit more of there's more awareness, almost more observing ego. That are we really going to fight about this now? Is that really what we're going to do? And so that I think there's some of that people have. I can think of a case recently in one of the transit places I was with, and they were arguing about a particular assignment. And I couldn't help but roll my eyes and look at people saying, "My goodness, we're worried about people on buses dying, and you want to fight about this?" So, and the union employer looked at me and said, we needed someone sort of slap us in the face and think, let's get out of our bubble and think about what's really going on. So I think there's going to be some of that.
So I know initially some of the parties worried that they wouldn't do well in a hearing, given the circumstances. It somehow wouldn't be fair, and it wouldn't be as equal to them. Maybe the labor side was less used to these kind of procedures. Do you think, how's it worked out? Do you think it's just sort of the procedures are working out fairly, that no one side, management isn't doing better than the labor, individuals are having their rights represented and all?
Well, in mediation, that was never relevant. And as I've talked about a lot, there's no doubt in my mind that this virtual world for mediation is as good, if not better, given privacy. I always tell the stories about, even in our office, we have a conference center that we built, with many, many hearing rooms. And even there, as much as it was designed so people who are in think about a sexual harassment case or a gender case, or when there's real hostility, we try to keep people in different rooms and not see each other, but they still might see each other in the bathroom, or they might in the kitchen. So there's always been this wariness that doesn't exist here. On the arbitration side, I think there was an initial notion, can either side be able to deal with this? And the answer is almost everyone who has done it, gone through it, comes back and says to me, it's much better than I ever thought. Candidly, I have not had any in-person hearings, but I've had hearings where people are in a room together. There is nothing more difficult, in my experience, as an arbitrator than try to listen to someone testify through a mask. To hear them, to hear nuances, perhaps to see their facial expression, it's non-existent. It's not successful. I think it's a bad idea. And I remind this of people, in contrast with actually doing what you and I are doing right now, where people can be comfortable and testify, and we can put in all of the kind of cautions that you'd want to make sure that people aren't being poached and the like. I think there was this fear. I'm very clear. We make people show me their phones and turn them off, and I confirm that and make sure I even make them scan the room so I can see there's no papers. There's a million things you could do, just like you did in an actual hearing. Parties, people who don't do arbitration would be surprised how often witnesses coming in bring in notes, not realizing they're not allowed to use notes. And I have to say, no, you can't use those. Turn those over. Please give them back. So it's not that much different. So I don't, there's clearly no, there is no aspect in terms of the tilting, in my experience again, of tilting the scales of justice on one side or the other. The only thing you have to have is good technology, meaning you have to have good internet service. Everything else is of no moment. And I have youth now who tell me that it is better for them in the arbitration because they thought they were disadvantaged by the inability to get witnesses. They don't have that any longer.
So let's talk a little bit more about how things have changed since you're doing virtual and all. I know one of the issues you wrestle with whenever one conducts a hearing is getting the right people in the room, or at a certain moment, making sure you get testimony, or as a mediator that you have discussion with some key individuals. How's that changed now that you can virtually connect? Is it that you're able to call in individuals and have a short conversation that you might not have been able to do in the past?
Well, in the business world and business mediation and employment mediation, it is infinitely better. When I need, often the person who's going to make the decision is not there. Whether it's even sometimes the corporate person or the CFO, like, can go everywhere. It can be the owner of the business. They usually would not indulge their side and spend the whole day at a mediation. Now, every week, I have a situation where somebody says to me, usually the attorney, I wish I could get in touch with the owner, Harry Katz. I wish he could hear what you had to say, Mr. Mediator. I said, well, give them a Zoom link. Next thing you know, the person comes in from Singapore, comes in from California. Yesterday, literally from Minneapolis, exactly what you just described. We brought that person in. That person had been very resistant, spent a little time with me, and lo and behold, we were able to resolve it. We also have a situation now when the parties, look, it's very hard to schedule. Right? The thought of going to another hearing, which is expensive and logistically difficult to get one witness, everybody tends to think, well, we'll have to figure our way out of it. Now it's go get the witness. Go pick up the phone, tell the person we're going to send them a Zoom. You can have 15, 20, half an hour to prepare the person, put you in a separate room, and then we'll put the person on. So there's no doubt in terms of witness availability and the ability to make a fulsome record, this has enhanced that possibility.
So I would imagine it's also allowed you to handle cases that you would otherwise have turned down or said to the parties, you've got to come to me. You're incredibly busy. You're in high demand. Maybe international cases or a case on the West Coast or, something like that. It must have it basically increased your availability.
In two ways. One, as everybody knows, I don't particularly like to travel. It's well known. And so I turn down cases usually all over the country. Now, since March, we're taking cases in California, Seattle. We had cases, well, really, I had a big business dispute that involved people in Africa, people in Asia, and people in Europe. We were able to do it. I sat right in the same place I am. We could do that. The second thing, which is literally, we're doing this right before Christmas. And so ordinarily I wouldn't have worked this week. Last week, I got a call about a pretty important case with a huge retailer that needed to have this thing resolved or go to enormous litigation like now. And so ordinarily I would say, look, I'm away. I'm not going to come back for one day. It's going to cost you a fortune. Instead, suddenly I said, I'll tell you what, if you're willing to start yesterday at 7:30 in the morning, I can do this till 12 o'clock, and we'll see if we can get it resolved. That never would have happened before. The people were in 7 different states, and we resolved the case. Actually, it went till 1 o'clock. And so there is clearly more availability. You can be more responsive to the parties. And personally, I can certainly fit cases in. The other thing is the hours are different. The typical neutral starts at 10 and goes to 5. Now we can start at 7, we can go to 12, we can start at 2:30. We had one last week that started at 5 o'clock at night because of the different time zones. We had people from Europe, we had people from California. We compromised, we got to 5 p.m., we went from 5 p.m. to 10 p.m. That is not something that you ever would do in person.
So you mentioned earlier a little bit about how there was some discouragement of more trivial issues or less critical issues in light of the pandemic and all. I also want to just talk about how the technology it may have changed things. For one thing, people don't have to worry about rush hour and driving home. So maybe they just continue to talk on and on because they don't face that. But maybe they face a greater sense of urgency of the sort you're saying. It really focuses their attention. Do you think the use of virtual does that? It either focuses issues more or gives people the excuse or opportunity to drag out conversations?
I think I'm looking forward to the empirical evidence with the social scientists on this. And what I mean by that, I have this anecdotal information that I have that Fridays, just like when a jury comes in on Friday, I would know that we would finish at 4 or 5. Usually people would like, coming. Now people are like, well, they don't say this aloud, but I think they're thinking, oh, I would have to get back in my car. I would have to get on public transportation. I wasn't going to get home until 7:30 or 8 o'clock anyway. So they'll continue to work and hold out until 7 or 8 o'clock at night, much later on Fridays than I can ever remember, interestingly enough. On the other hand, since people a lot are controlling their whole lives and this sort of fuzziness between our personal life and our professional lives now, because many of us are working at home in our world, people want more structure to their lives. They are afraid that everything is going to bleed into each other. So I think that sometimes it actually makes people focus more. I've said to them, make believe it's 4 o'clock in the morning and we're meeting. I know it's 11 o'clock in the morning, but I'm not going to be here at 4 o'clock in the morning. You're not going to be here at 4 o'clock in the morning. Just mentally come to terms with that the deadline is 2 hours from now, not 14 hours from now. And even though people initially laugh, I observe in some cases that actually happens. So it's much, if I would say to parties in a collective bargaining mediation that I was only going to be available for 4 hours, they would have freaked out. Now everybody's like, oh, that should be enough, because everybody's ready to telescope. So you have both considerations. I'll be interested later on when we look at this, whether we really know whether it speeds up or slows it down. I really think it depends completely on the parties and the case.
So I know a lot of your work involves mediation, arbitration, but some of it involves negotiations. I've read in the press you've been involved in the complex negotiations involving New York City's employees. What about those instances in which there's negotiations going on and it's happening virtually? Has the presence of virtual technology changed the way negotiations have proceeded?
Well, so for example, when I'm involved with that, like for example, I'm responsible for the changes in healthcare for the 1.2 million workers in New York City. And so I'm not the mediator. I'm sort of involved with the, sort of what we call the tripartite. And so what I do think happens there is exactly what I said to you earlier. You can get people, to get 7 union leaders to all come to the same meeting on the same day. And to get not only, for example, in the city, the commissioner of labor and the head of the budget, and also get the first deputy mayor, and arguably the mayor, if I need to speak to the mayor about some ideas. If I want to talk to the consultants, imagine getting the consultants to do healthcare and do, we have 5 or 6 major consultancy groups who are all over the country. We can bring them all together. So I think it actually facilitates better conversation. These breakout rooms are very private that we can use when we have these negotiations. And someone can sit there and say to me, look, I'll tell you this, even though you're not the mediator, but I'm never going to say this publicly unless I know the other 6 unions are ready to say yes, because I don't want to be the first one to break the alliance or break the normative standards that we follow. But I would be willing to do this if you can figure out how to get everybody else to also be the ones to bring forward. So yes, I think it actually facilitates it. It certainly facilitates availability. I get people in the room that I never could get to beforehand. They just would not be, you can imagine what it's like to just schedule a meeting with, 7 union presidents and literally 12 commissioners. I mean, it's implausible, but it's not implausible anyway, any longer to say, we're going to need you for 20 minutes at some point during this day. And the person says, sure, I'm not going to be so highbrowed as to say I can't give up 20 minutes when you're doing that. So I think it does actually facilitate it. The technology it does exactly what it was supposed to do. It brings more access and it brings more thorough examination of issues, because every time you have a negotiation, everybody has a desire. I wish I had a little bit more information before I made a judgment. Now there's really very few excuses for not getting the information you need, whether it's emails, whether it's Zoom, whether it's conference calls, whether it's overnight kinds of stuff that we used to. I mean, it's just really quite remarkable. Someone will send me we need this document. Years ago, we'd say, all right, well, we'll get it to you next week. Now, not only do I get it emailed, but I get it sometimes put up, parties go through it together, and we can fight out the language as opposed to putting it off for tomorrow. So I think it's very, very conducive.
So let's talk about the future. As we have now begun to return to work, and as we hope with the spread of the vaccine, there'll be a more systematic return to normal work. What do you think will happen to your work? Will we continue to have virtual hearings? Will it be kind of a mixture? Will we return to everything face to face? What's your forecast?
Well, my forecast is, again, all of the above. This will be all entirely relationship based. And what I mean by that, as you're the neutral, I'm the neutral with a lot of relationships with police. Police have been working. But yet I've been able to say to them, I'm not coming to work. I'm 68 years old. I'm fearful of getting sick. And they will indulge that. I don't know whether they will indulge that a year from now, but maybe they will. The one thing, again, those parties even want prompt responses, and I can give more prompt responses there. There are other relationships that will never go back, that we will just do it this way. We've realized that instead of literally setting aside an entire day to do matters, we have now been doing them in an hour. Everybody's more efficient. There's been no fall off in the quality of the dispute resolution processes, and they'll never go back, and they've already told me they'll never go back. I have arbitrator colleagues who've told me, because of their use to this, I'm not going to take any cases anymore that I have to travel. So I think that's it. Now, so I would think it's primarily going to be hybrid. It may not even be uniform. There's so many agreements that are now being signed, the parties are sending me where I'm serving, that say, shall be virtual or in person, depending on circumstances as determined by the neutral. So they're open to the fact that this could go on for years. And lastly, I don't think workers are going to go back en masse the way they did anyway. So let's assume that, well, these hybrid work arrangements where someone comes to work 3 days a week, but works from home 2 days a week, or flipping it. How are you going to be sure to schedule the hearing on the date when that person was scheduled to be in the office? You're not going to do that. You're going to schedule it around as many people as you can, recognizing there are other people who have already agreed or are allowed to be living in Austin, Texas, or in Atlanta. And we're not going to stop the system. So I believe there's no chance that my Zoom account is not going to be important in the future. It's almost improbable. And more importantly, I think the parties are pleased. Busy arbitrators schedule out 6 and 7 and 8 months. It's absurd. I've talked about it for years. That's why we at the Scheinman Institute, we try to educate the next generation of neutrals and practitioners to be more responsive. Well, this is also given the chance for, busy arbitrators, busy mediators, busy advocates to be able to do things in a more time-sensitive way, because there's no reason we can't find a few hours. You don't have to travel. You don't have to spend the money to travel. You don't have to get on a plane. You don't have to worry about parking. You don't have to worry about child care coverage. You can do it all right there, and let's do it.
So we've covered a lot of ground. Let me just ask, sort of as a wrap-up question, is there anything that we've missed, something that strikes you regarding either the substance of what you're doing or how you're doing it in the pandemic that we haven't touched upon so far?
The only comment I would make is I think it's not just our ingenuity generally, but also just the extraordinary flexibility that human beings have the capacity to engage in. I mean, I just look, we keep track. I'm up to 190 some odd matters that we have done by Zoom since March. I don't know how that would compare with a normal year, but that's a lot of work. And so the fact is, I have some mental pictures of people who were totally resistant to the idea of change. It was a big deal for me when I went from an AOL account to a Gmail account. So just think of it that way. Yet I'm telling you, what I cannot get over is, one, how lucky we are that we're in a business that can be responsive to issues that arose that really are important in society. That's one of the reasons I continue to do what I do. These are pressing issues: employment, healthcare, whether or not people are going to be keeping their pensions, whether or not a business can survive, whether or not we can talk to a landlord about renegotiating a lease and the landlord says we need to have a mediator, whether these two business partners who've always had this tense relationship can figure out a way to either go ahead or leave in a way that doesn't cost them their whole life savings in litigation costs. So I think that's what's going to be different. And that's what I've learned this year, is that parties are very adaptable if they can see a solution or a decision, arbitration, mediation, that they feel was really just fundamentally fair. And the fact that this facilitates it, I think that's taught me something that when you talked to me, you and I spoke in March and you said to me, what's going on? I said, I don't know if I'm going to do anything this year. Who knows how long this could be? Not only did we not know the length of it, but, for all I knew, everybody would just stop. They wouldn't want to do anything. They'd all be too distressed. And we can handle it. The other thing is we can have human contact without having human contact. And that's a pretty extraordinary thing. That's why I insist everybody puts their camera on. I want to see that person. I want them to be able to see me. It gives you that. And last but not least, seeing a person in their home, seeing a person in a different environment also gives you a better insight into that person and a better window into their soul. And the more you know about people and you can relate to people, the more helpful you can be with all of us in helping to solve problems, which is, what you and I do for a living.
Well, thanks so much. Thanks for this interview. And of course, thanks for everything you do for the Scheinman Institute, for ILR, and for Cornell University. I look forward to seeing you in person at some point.
Take care. Nice to see everybody happy and healthy. Bye.
Take care.
This has been a production of the ILR School at Cornell University. ILR, shaping the next 75 years of work.